because here he's invoking the verse. So Attar responded, the first ablution suffices you. If I perform the ablution for the dawn prayer, then it is valid for all other prayers as long as I don't become ritually impure. So here you have a legal authority who is now giving a ruling for something that was unclear to his student. Now he doesn't really talk about what that could mean, when you rise up to pray means. He's just saying this is the way it's done. So the Quran says something and he's saying, well, this is the way I interpret it, and this is now where we're going to situate with the law. Now, that conversation took place in Mecca. In Kufa, which is in Iraq, of another famous jurist named Ash-Sha'bi, he said, I don't care if I pray 5 prayers with 1 ablution as long as I don't become ritually impure. So now you have in a separate region the same comment. And then in Basra, another region in Iraq, you have a famous jurist who says, a man can pray with all his prayers with 1 ablution so long as he has not had a polluting bodily function. And then Ibn Sirin, who was also in Basra, he said, predecessors used to make ablution before every prayer. However, based on unanimous practice of contemporaries, he believed that ablution is only necessary when a person becomes ritually impure. And in other words, there were Muslims who were making ritual ablution before every prayer, but this jurist, this legal authority said that, well, what's happening in the culture? What's happening in the practice of the Muslims of my day? And in that, people were only making ablution after there was a ritual impurity. So in other words, there was a difference between what the Quran may have meant and how it was interpreted, and then what became law. So you see this whole transition that takes place from what the Quran says to what is actually happening on the ground. Another question came up. Well, could this mean when you rise up from sleep? Does this only mean when you take a nap, or if you're getting up for the morning sunrise prayer? And then this was debated also. So there's a lot of wrinkles to this. I just wanted to bring to your attention some of the ways in which a ritual act that is in the Quran is then dealt with from a legal perspective in Islamic laws and jurisprudence. Now, the next case, the one that focuses on my particular research, deals with criminal law. And just to give you some perspective, I can talk to you about the beauty of the Sharia, or the ways in which it's been expressed in different facets of Muslims' life, like the demand to stand up for justice, or the demand to give charity whenever possible. But I also know that when you turn on the TV or you see our president talk, it gives there's a very different picture. And for that reason, I thought it was important to touch on not only my project, but something that's a little bit more, the only word that's coming to my mind is sexy, and it's a pun in some sense, because I'm going to be talking about adultery. So, but anyways, it's a little bit more in your face. And the reason I'm also talking about this is because it's not so much that Islamic laws need to be changed because non-Muslims or somebody in the White House is saying that they need to be changed. It's more that, we need to understand how the tradition works, and then how the tradition works, and then how does it compare to how people use it today. And then figure out what the difference is, what the distance is between that, and then how do you close it, or how do you change it. That is really important. So I'm coming from it from that perspective. So in Islamic criminal laws, the Arabic term is zina. And zina can mean fornication, and fornication means that the person who has illicit sex is unmarried, okay? And then there's adultery, which obviously means a person who is married has sex outside of marriage with someone who he or she isn't married to. So what came to be in Islamic criminal laws is that fornication was punished based on a verse in the Quran. which says, as for the zaniya, which is the person who the female person who commits zina, and the zani, who's the male person, flog them 100 times. This is in 24:2. And the punishment for adultery, which is death by stoning, is based on reports involving the Prophet and adultery cases. Excuse me, so I'm not going to get into the authenticity of these reports or with some of the different ways in which these reports may have emerged. But ultimately, the point I want to make is that the authority for the capital punishment in Islamic laws rests with prophetic authority, not with Quranic authority. And the prophetic authority has, over time, been used and misused. At any rate, here's one report that exists in the literature. It says, we were traveling with the messenger of God, meaning the Prophet Muhammad, when a man came up to him and said, I am the one who committed zina. In other words, he confessed to this sin. And the Prophet sent him away, and he kept returning to confess. After the fourth confession, the man remained in place because the Prophet did not send him away. The messenger of God gave the command, and the man was stoned. So zina, which means illicit sexual intercourse, such as fornication or adultery, when we read that first portion, we were traveling with the messenger of God, when a man came up to him and said, I'm the one who committed zina, which one is it? Is it fornication or adultery? How do you know it's fornication?
It's adultery because that's the punishment for that is stoning.
Right. So the stoning punishment indicates that it's adultery. But if you didn't have the stoning punishment, you don't know what the you don't know which form of zina it is. So it's the context that tells us what the zina is being referenced to in this report. But without knowing the context, it's unclear. And so this was something that Muslim legal authorities had to deal with. And so how are they going to deal with it? What is the type of zina that is subject to capital punishment? So they said, well, it has to be a non-virgin, a thayyib in Arabic. And they derived this from a verse in the Quran. It says, who turns to God in repentance and worships God, whether thayyibat or abkar, which are virgins. So they said, anybody who is a non-virgin is subject to stoning. So a thayyib plus zina equals stoning. This was early Islamic laws. But what happens when you have a non-married thayyib, a non-virgin, let's say a divorcee or widow, and they commit zina? That's not adultery anymore, is it? Right? Because they're not married. The presumption is that a non-virgin is married. But you can also have non-virgins that are unmarried, such as a divorcee or a widow. So in that case, are they subject to stoning if they commit illicit sexual intercourse? So this is a gap that came up in Islamic laws. So how did Muslim jurists deal with this? They came up with another term. It's called ihsan in Arabic, and there's no real translation for it, so this is the best I could do. It's the state of being chaste from illicit sexual intercourse. That's the best way to describe it, really, because there's one English word that can capture the Arabic of it. So it's a state of being chaste from illicit sexual intercourse. And they came up with this word and this term because it provided flexibility and restriction. How so? This jurist that lived in the middle of the 8th century, named Al-Zuhri, he lived in Damascus, he said, if a man has illicit sexual intercourse and has ihsan, but has not consummated his new marriage, then he is flogged 100 times. So what does that mean? That means that you can have ihsan and you can have sex outside of marriage, but because you haven't consummated your active marriage, you get flogged. And in other words, you can commit adultery without being subject to the stoning punishment. Do you see how? Does anybody not follow me? If not, it's okay. You're going to raise your hand. Okay. So a thayyib, but this was actually more restrictive, because a thayyib who's a non-virgin who has sex outside of marriage and has not consummated the act of marriage, they would be subject to stoning. So you can see how al-Zuhri's opinion becomes more restrictive by using the term ihsan. Another jurist who lived in Iraq named Shaybani, he said, ihsan, which is chasteness, Muslims who are free, sound-minded, post-pubescent, and have licit sexual relations. So that means somebody to have ihsan have to fulfill all these conditions. So if you're not post-pubescent, and if you never had licit sexual relations, so you can be a non-virgin because you haven't had licit sexual relations, you're not subject to ihsan, which means you're not subject to the capital punishment. A Shafi'i, who was a very famous jurist, he said a Muslim who has ihsan is subject to stoning only after he consummates a marriage with a free Muslim, Christian, or Jewish woman. In other words, it has to be one of these restricted categories. So if a Muslim man marries a Zoroastrian, or possibly one of the other religions that existed during his time, he doesn't acquire ihsan, so therefore he's not subject to the punishment of stoning. And another jurist, he said a female Muslim who gets married without the permission of her guardian and then consummates her marriage does not acquire ihsan. And in other words, that she too is not subject to the capital punishment. So there are all these different ways that jurists were using the term ihsan to narrow the conditions under which the capital punishment could be applied. Now I just want to bring in some other ways in which the traditions or the reports about the Prophet were used. A man from the tribe of Aslam, which was don't worry about that, came to the Messenger of God and confessed, I have wronged myself because I have committed zina, and he wanted to be subjected to the punishment. So the Prophet sent for his people, and when they came to him, he asked them, do you know if this man is mentally competent? And they said, no, the only thing we know is that when it comes to competence, he is the best among us. So the man came back and confessed 3 more times, and each time he confessed, the Prophet sent him away to his people. 3 times the Prophet asked the man's people whether he was sane, and 3 times they said that he was. When the man confessed for the 4th time in the presence of the Prophet, then he was given the command to be stoned. And then in the same narrative reports, the messenger of God asked, did you enter her like a way a needle enters a coal jar or a rod into something? So this idea of actually understanding what the crime is or what the offense is. So what did this do for adultery laws? If a person confesses, then 4 confessions are necessary. And because the reports the Prophet sent him away, they use Muslim jurists use analogy to say, well, you also, if somebody comes and confesses, you also have to send them away. So a judge has to send a person away 4 times, and they have to be deterred. They have to be deterred from confessing. Establishment of mental competency. Right? We read that the Prophet said, ask for his people, is he mentally competent? So jurists drew the analogy that you have to establish mental competency. The person has to know that they're committing a crime or committing an offense. Confirmation of the sexual act. So you have to ask the question, did you enter her like the way a needle enters a coal jar? Like there has to be an actual confirmation of penetration. Confirmation of ihsan. Does the person have ihsan? And we saw all the different ways in which Muslim jurists narrowed the conditions under which ihsan could come about for a person. So these legal stipulations, among others, became necessary not only for confessions, but for eyewitness testimony. And in other words, if someone was going to accuse somebody of saying that they committed adultery, all these evidentiary burdens have to be met. Now, in my opinion, they're pretty hard to meet, especially thinking about the act itself and whether 4 witnesses can witness the act of penetration and then be able to describe it to the judges. That had to be done. So for all intents and purposes, I really think Kim Kardashian may be in trouble. But outside of her, I'm not really sure how many people can actually be convicted on eyewitness testimony. And by the way, in the Quran, the punishment for wrongful accusation is 80 lashes. So if you accuse somebody of adultery or fornication, and the conviction can't happen because all the evidentiary burdens aren't fulfilled, then you get flogged 80 times. So it's a deterrent, because remember when I showed you the 5 objectives of the Sharia, one of them was preservation of honor and dignity. So accusing somebody of adultery is a pretty heavy thing to do, or a fornication. And so for that reason, it is mitigated by the fact that the consequence of wrongful accusation is 80 lashes. So what's happened in the modern age? It's been turned upside down, on its head. That's what's happened. And I want to bring this home with this incident, that in Afghanistan, a woman was stoned to death for adultery in a Taliban-controlled region. So there was a 19-year-old girl named Rukhshana. She was forced into a marriage, but she ran away with her lover. And what happened is that she was caught, and village elders convicted her of adultery and then had her punished, which was, had her stoned to death. But now that we've learned what we've learned, here's the questions that never got answered. Did she have ihsan? Do we know this? We have no idea. Was her marriage, forced marriage, quite frankly, consummated? Or was it not consummated? Because that can have an impact on whether or not there was ihsan. Was she mentally competent? Did 4 witnesses view the sexual act? And there's no evidence that that took place. So you can see how, on the one hand, there's a claim to be following Islamic laws, and how at every single turn they were violated. And that they ultimately, put this poor girl to death for whatever their reasons were. So in the Islamic legal tradition, you have a narrowing of circumstances under which conviction can take place. They're narrowed. And in modern day state actors, they've actually tried to broaden it. They flipped it on its head. That's where the change occurs between the classical period and what state actors are doing now. So I'll close out with this, that when we think about in the modern sense, what it means for the Sharia to be expressed, what does it mean for criminal laws, particularly when it comes to corporal and capital punishments, what is their place in any criminal legal system, but let's just, obviously for our intents and purposes, the Islamic legal system, how do we adhere to these 5 principles? How do we maintain someone's dignity? And how do we maintain, quite frankly, life or intellect? And these things need to be asked in order to figure out in what ways we can accommodate new ways of thinking about punishment in general and in the Islamic legal system in particular. And I'm more than happy to talk more about this in the Q&A section. Thank you so much.
Well, thank you very much for a remarkably enlightening lecture. What I had hoped, and I imagine that we will hear from you in future, because I think I can see the thoughts developing. From the Indian point of view of Muslims, there is a serious conversation between the 2 elements that you've spoken of, the divine and the human part. And the divine is immutable, as we've been made to understand, and it comes from the Quran. But there is, as you've made us understand, this vast area of human element that also includes those decisions that were taken by the caliphs, the chosen caliphs, the companions of the Prophet, and some things that have happened later in recorded hadiths and records of either the students of Imams or Imams themselves, so the 4 schools of jurisprudence. The interesting thing for us in India, and I believe this would be true anywhere, is to what extent can people insist that this is divine and therefore immutable and you cannot touch it. And that's where the demands of modernity come in, where particularly in plural societies, perhaps it's easier in a sense in Islamic societies, but in plural societies where any attempt to interpret it in more liberal and more modern terms is seen as an attempt to interfere in the Quran or interfere in Islamic law in Sharia. Now we have Dr. Javed Akhtar here. If I understood what he told us 2 days ago, is a very clear distinction between the immutable Quran and the produce of the human element, which is interpretations, memories, records, communicated from one person to the second and to the third, etc. So at some point of time, I believe we'll have to tackle this, and no better a person than you for having given us this remarkable exposition. And it will be interesting to see where the divine element stops and the non-divine element begins. We have experienced in India a popular, when I say popular, not in terms of what ordinary people imagine, but what the clergy or the ulama positions they take, and then that translates into the popular positions that people take, is no clear divide between the divine and the human. And I think that's the big challenge. And for me, the takeaway of your lecture is that looking at specific examples, there is a need for defining this divide between the two. As I was saying to you over dinner, India, if I'm right, has never had Islamic criminal law. We have, to this day, personal law, and the personal law is resolutely defended, so much so that reform that has been done in Islamic societies across the globe was not attempted in India because of our political commitment that we should not touch something that belongs to the minority. But it's becoming more and more difficult, and it happened when, unlike most countries whereby legislation, triple talaq was outlawed, in India we had to wait for the Supreme Court to do it. And it is almost seen as a major celebration that the Supreme Court finally indicated that triple talaq was not a valid part of Islam. And it'll be interesting for all of you to look at that judgment. It's called Shaira Bano. There were 5 judges, interestingly. One was Christian, one was Parsi, one was Sikh, one was Hindu, and one was Muslim. Now, I'm not sure that this was done deliberately, but it matched well. And now, in this, the Sikh judge, who was then the Chief Justice, he and another companion judge, who was a Muslim, who joined him in that opinion, came to the conclusion that triple talaq is truly 1400 years old. And it is part of personal law, and it is not for the courts to interfere in it. Then, strangely, the court said, or these 2 judges said, that although we cannot interfere with it, but this was perhaps on a concession by the Muslim party, it's something that Parliament can do. And so we suspend it for 6 months and ask Parliament to legislate. So 2 judges said this, and everyone assumed that this is what the law is, because Chief Justice announced his judgment first. Then came Justice Kurin Joseph, the Christian judge, who said, I've looked at the Quran, and I don't find any justification in the Quran for triple talaq. So what are we all getting worried about? There is no such thing as triple talaq. It's over, finished. Now that still leaves 2 judges, the Parsi judge and the Hindu judge. The Parsi judge and the Hindu judge said, well, it's true that triple talaq is whatever, 1400 years old, but by an act of Parliament in 1939, it was incorporated into the law of the land. So it's not standalone personal law, it's personal law that's become part of the general law of the land. And the general law of the land is subject to the Constitution. And the Constitution provides Article 14, equality, Article 21, dignity, autonomy, and so on. And therefore, it goes. Now, one would imagine that these two judges were somewhat unimpressed with Islamic systems. But Justice Rohinton Nariman, the Parsi judge, actually very categorically said that the Islamic law of marriage and divorce is shockingly modern. First time this word has been used, shockingly modern. And I believe that it's shockingly modern because if you just think that 1400 years ago, there was a perception that you don't have to remain connected in an unhappy marriage, that there was a provision for the man to get out of a marriage, but there was also provision for the woman to get out of marriage. And often people say to me in India that, look, the man has a unilateral right. He just says talaq and walks away. But the woman has to go to a qazi or to a judge to get the same thing in khula. And usually my answer is that I think that's again a misunderstanding, because the man and the woman have to first go through a process of reconciliation and mediation, which involves 2 people from both sides. Now, if that's the case, and if it doesn't work, the mediators must be reporting to somebody that it hasn't worked. And then they report to the qazi. The qazi can then say, well, we'll accept your divorce, but please make sure that you have paid the mahr, which becomes due upon the marriage, but which quite often is postponed till the time of divorce, and ensure that you look after the children and ensure that you provide maintenance to the woman and her residence for the period of iddat, which is 3 months. So in that sense, it seems somehow unclear as to why people assume that talaq is, even if it's talaq and not triple talaq, that talaq is just something that you say and you move away. For the woman, that she needs to go to a qazi and not just simply say khula, 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 I'm going, is because she needs all the things that the man has to give her, which means the maintenance, and now under Indian law, something called provision, which Supreme Court says is a one-time settlement. She needs her meher if that hasn't been paid. She needs maintenance for the children if that hasn't been paid. And therefore she needs some adjudication and assistance to be given by an authority. And that's the reason why she needs to go to a qazi. Divorce by mutual consent, obviously you need a third party to decide that what can be the divorce by mutual consent. So the trouble is that often people think of talaq and khula, if at all they think of khula, in terms of a standalone system without reflecting on the difficulty of getting out of a bad marriage if you are not doing it under the Islamic system. I'm sorry to report that I have myself handled cases in the Supreme Court of divorce under the ordinary law, which have gone on for 25 years. and I've heard the woman say it's not worth it anymore. There's nothing left. 25 years is a long time. In one case, the marriage was 25 years old, and the son who was with the mother was 24 years old. And I looked at them and I said, my God, what amazing thing is this? A 24-year-old son who's refusing to speak to the father, and it had to come all the way to the Supreme Court. And because the Supreme Court had this very compassionate judge in Justice Korean Joseph, that he said, let's find a solution, and a solution finally was found. Now clearly there are things about the Islamic system that in a sense offer a lot more. So for a distinction to be drawn that we are, in our two systems, we are, let us say, at least equal, but we are different. And this is the big challenge in our country, is whether what can be approved is something that comes from the Western system or the common law system, or whether there can be options, Islamic and the Western system. Now we of course have all religions. We have Catholicism, but they found their own way of, through annulment and so on, they found their own way of releasing people from the marriage bond. We have the Hindu religion, which didn't have a concept of divorce. So the concept of divorce was introduced by way of special legislation called the Hindu Divorce Act. So now you can get Hindu divorce under generally the same parameters as you can get a talaq or a Islamic divorce. So these are questions that we are grappling with, and your perception. I would just have hoped that your research in specifics of criminal law took us away from a little more that one would have hoped to hear from you on what is divine, and how the hadiths don't have the same binding capacity, if at all. The hadiths don't have, and then of course in hadith you do have an option of choosing one over the other, and categories of hadiths, etc. But for future, maybe one day I would want to come and hear from you. What are the interesting differences between what is binding and immutable in the Quran and what is available in hadith, and what would be contextualized, particularly from the hadith, as being a matter of circumstances then. And when, if it's a matter of circumstances then, as has happened in some of the examples you gave, could we take it that since circumstances have changed, one can interpret the hadith differently? And there, of course, as you ladies and gentlemen would know, there are several instruments available in Islam. The ijtihad, which is interpretation, not to be done by everybody, but people who have the scholarship to do it. Also qiyas and other forms by which you can make an interpretation of the Quran progressive, and therefore escape from this constant charge the world over that Muslims are inhuman, that they are perversely backward, that they are misfits in plural society, etc. The other interesting point that comes to mind, and I want to share it with all of you, is that in our recent judgments, a distinction has been made between what the court calls constitutional morality and what is faith. Somehow there's an easy assumption that faith is not part of constitutional morality, which means we have a constitution which is faithless. It can't be, because there are two provisions which entail to faith, Article 25 and 26. There are two provisions that entail to for rights of minorities, including Muslims, for educational, cultural rights, and so on and so forth. But somehow, all that seems to have faded, and this happened, you ladies and gentlemen would be interested to know, this happened most recently in a case where a particular deity in Kerala had a restriction for the sanctum sanctorum being accessed by women between the ages of 10 and 40. And the Supreme Court said, 4 men on the Supreme Court said, this restriction has to go. It's against constitutional morality. There was one lady on that bench, Justice Indu Malhotra, who said, you cannot impose rationality on faith. You either accept faith or you don't accept faith. Now, if you accept faith, then you can't insist that rationality should redefine faith. And then, in order to define what are the contours of faith, it's not for judges to do, but it is for people of the faith to decide. It's a big question, and I believe in the years to come, this question will be considered over and over again. It's easier in a plural society to consider these questions when the majority is involved. It's a little more difficult when the minority is involved, because the minority is accused of being unreasonable in asking for too much, whereas majority is seen as asserting what is its democratic right. So thank you very much for this very, very enlightening lecture. And I hope that the opportunity you've given us both, and I cannot claim any scholarship anywhere near the main speaker, but it was very enjoyable and brought back a little bit of university nostalgia. So thank you very much.
As we're gathering here and we have a chance for questions and answers from both of our guests, we would very much appreciate it. I would hope that also you remember, and I'm going to pass this over to Professor Hawk, so you can come one side or the other side. Tomorrow is Election Day. So we need you all out to vote. All of you have got to go vote. All right? Those of you who can, Federic students, you're probably not ready yet, but we want you to vote if you can. Are there questions that we could invite our distinguished guests to offer reflections on?
Maybe we can.
I'll come back
Perhaps
here.
the change of government is going for.
And if you could introduce yourself so that we get to know your name and then also ask your question.
I'm Latif Sayed, and I have a question for Dr. Rizwan. You talked about ihsan in relation to the adultery. If I remember correctly, there is a hadith which says in the hadith it describes like Prophet Muhammad Sallallahu Alaihi Wasallam and asked 3 questions. What is Islam? Then he asked about what is Iman, and third the question was what is Ihsan, and the Prophet said Ihsan is praying.
I'm sorry, I don't mean to be rude at all. What you're thinking about is Ihsan with a sin, and I'm talking about Ihsan with a Sad.
Okay.
So there's 2 different Arabic letters, and one means goodness, and another means chasteness.
Oh, thank you.
And the one I'm talking about is chasteness.
That clarifies
And I know this word's been thrown around, and for our guests who don't know Islamic terminology, hadith is a reference to the sayings or actions of the Prophet. So when the person who's asking the question said, well, I've read this hadith, what he means to say is I've read this story or this narration about the Prophet in which he supposedly said X.
Thank you, Mr. That's clarified, madam.
Thank you. We have another question over here, Professor Hawk. You over here? Please. Please.
Thank you. Thank you. I am Khandakar Hasanat. I have a simple question. Is the the forgiveness, does the forgiveness has a role? And I think my repeatedly, I see if the person, somehow forgiveness, if you could forgive, if there's an occasion for forgiveness, forgive the guy, whatever he has done. So my question, given the fact, protection of the person, protection of the family, protection of the community on the three top, on the top of the list, by forgiving the guy in the current age, is it kind of consistent with Islam? That you are protecting the person, you are protecting the community, you are not disrupting anything, extramarital, premarital, all kind of things going around, the war is not coming to an end. So is there a role? Even without that, is there stoning? Is it symbolic? Does he have to lead to death or disfigure pain? I have some of those questions because I think, I have a feeling we can somehow make it more, we can present, it's important to me and it may not be important to a lot of people, they're presenting a different face of Islam in the changing world. If we could do that.
Sure, thank you. So forgiveness is actually preferred in Islamic criminal laws, particularly when it comes to these corporal and capital punishments. There's another version of this hadith, this saying, in which the man comes and confesses to the Prophet that he committed adultery, and the Prophet says, "Didn't you just pray with us?" Meaning like one of the ritual prayers. And the man says, "Yes, I did." And the Prophet responds by saying, "Well, your sin has been forgiven, so go away." And certainly in the Quran too, there's repeated notions of forgiveness. The time when it becomes mandatory is when a person is convicted. And that is no different than in criminal laws anywhere. That's what distinguishes criminal laws from civil laws, including in our own system, right? Once the gavel comes down, it's game over. Certainly there's notions of appeal, and that is, in some ways a modern phenomenon, and we can, those are ways, and those are spaces to explore in Islamic jurisprudence. But the idea that once there is a conviction and a punishment must be implemented is in fact very much in line with the way legal systems work. In fact, right after 9/11, there was a Muslim 7-Eleven owner who was shot in the face by a guy who came in and was angry with him, and he was convicted and he was given the death penalty. And the Muslim owner actually went to the court and says, "I forgive him. I forgive him, don't have him executed." And the state of Texas still executed him. So the idea that conviction results necessarily in punishment is just the way criminal law works. But the idea that you can be forgiven, and the idea that there's space to show as much leniency as possible, that certainly is very much within the Islamic legal tradition. There's a very famous saying, a hadith of the Prophet, especially when it comes to these corporal punishments. It says, "Drop the corporal and capital punishment in cases of doubt." In other words, this idea of proving beyond a reasonable doubt. So, this idea of qiyas, this idea of analogy, there was a lot of Muslim jurists who were not willing to draw analogies between two similar crimes because they said that the analogy, the analogous relationship, there's doubt in it. And so because there's doubt in it, it necessarily causes you to drop the punishment. So they said, we're not going to treat this new case as a new criminal case. So again, to reiterate, this idea exists, it has existed, and that's why I explain, or I try to impress upon you, that the ways in which the tradition has dealt with criminal laws, and in particular with capital and corporal punishments, in the pre-modern, ironically, in the pre-modern period has been inverted in the modern period by state actors or those wannabe state actors like ISIS and the Taliban, and they've tried to find ways to convict rather than forgive. Whereas in the laws themselves, it's the exact opposite.
Thank you.
Good evening. Thank you both for your lecture and for your comments. My name is Hind Mekki, and I'm interested in how the masses, for lack of a better word, engage with religious rulings. And I'm specifically thinking about the case of Noura Hussein in Sudan, who was convicted earlier this year and sentenced to die for killing her husband. The Sudanese court said that it was a premeditated murder, and she said she killed him out of self-defense because it was a forced marriage and he raped her, and that he continued to do so. And then because of international outcry, she was saved from being executed and was she was just charged with manslaughter and fined. And then more people in Sudan are calling again for the death penalty to be reinstated. So I wanted to know, A, if you have any thoughts on her case specifically, and then B, generally, how, is this a modern phenomenon that, kind of the masses is engaged with religious rulings in this matter, or is this something that we can also find examples in Muslim history across the world?
Yeah, so thank you. So first, in the American legal system, we have criminal law and then we have civil law. And in the Islamic legal system, the criminal law is broken up into three categories. One are the hudud, which is what I focused on, which are these corporal punishments and the capital punishment. Another is, in Arabic, it's called ta'zir, which means discretionary punishment, which is really at the discretion of the state. In which the offenses don't fall in the category of these hudud, these fixed penalties. And then the third is called qisas, and qisas means retaliation. And so homicide falls under qisas, which is retaliation, and so therefore it's treated differently by the state. But it sounds like to me any other case where you have killed her husband and now the courts have to decide, and if there is public outcry, then there's public outcry. I don't think there's anything, at least based on what you've told me, anything that makes it uniquely Islamic. It's more so just that it's a criminal case, and perhaps there would be outcry in other countries or in other societies as well, and it seems like that's what's happening there.
We have a question back here. You can introduce yourself.
I'm Imtiazuddin. What is the scope or latitude in Islamic jurisprudence about paradigmatic interpretation of fiqh or sharia? My question is motivated by the fact that human societies are not static, their values and their interrelationships constantly change, and everything is relative. We should not be so fixed on certain things which may not be very relevant. What's your answer?
Yeah, thank you. It's a great question. The idea of culture being part of the calculus in determining laws is very much present in Islamic jurisprudence. In Arabic, there's a term called urf, which, for lack of a better word, means what is generally known or what is well known, and sometimes that depends on culture. So that's very much part of determining Islamic laws. Now, the idea of whether or not something can be changed, there's something in legal philosophy called legal positivism, which is the law is the law, and if there's certain rules that exist, then they have to exist. And there's something called the interpretive theory. And this is something that we here in the U.S. deal with all the time. For example, we hear about, Supreme Court jurists who are constructionists or originalists. And those terms are being used for is the original intent of the makers of the Constitution. And then how do you apply that to the modern case? Antonin Scalia was a constructionist in that way. So, a lot of the lack of a better term, conservative judges tend to be that. Then there's also those who are interpretive, and they say, well, there's actually a living Constitution. So the Constitution that you and I abide by today as U.S. citizens is not the Constitution that said one white man equals 3/5 black man for voting. We believe in a Constitution that's very different. And so that debate has existed and ought to exist, in my view, in Islamic jurisprudence, is that what are the underlying principles, and then how do you apply them in the new cases? So when it comes to corporal punishments and capital punishments, the evidentiary burdens are so high. You know, I mean, this is my work, so I can talk about it easily, and, you know, I think we're all adults here, so we don't have to be shy about it. But I cannot imagine how it's possible for 4 people to witness the act of penetration and then describe it in the exact terms to a judge. I mean, why was that created? What was the purpose? Because the idea, in my view, is not about implementing the punishment. You know, one thing that I consider, and that there needs to be a conversation about, is that how did law function in the pre-modern period versus the modern period? Now, when we have laws in the book, we tend to enforce them. But in the pre-modern period, there was no state, and what I mean by pre-modern, I mean is prior to the nation-state model. So the individuals or the authority or the body that implemented laws, their power was limited. Particularly when you think about, you know, they didn't have cop cars and stuff like that. So if you're living in one area and you got to go 100 miles to implement the law, that can be a challenge. And so law had different functions, and one of those functions was to communicate a moral or an ethical position. And so when we sometimes, you know, when we're angry, say, I'm so angry I can kill that person. Well, I don't think any of us wants to kill someone, God forbid. Like, that's not what we're saying. We're trying to convey how angry we are. And so these jurists, when they implement these high evidentiary burdens, what is being said here? Well, adultery is so bad that if you got caught, you'd be stoned to death. Or you know, it's in that way that there should be space to consider this stuff. And that then allows us to consider, you know, what are the ethical underpinnings, taking an interpretive approach to the Quran or to the prophetic practice, the living Quran, or the living prophetic practice, or the living U.S. Constitution, rather than saying, well, we're trying to figure out what the framers thought in 1776, and that's what I want to be. That's the type of U.S. citizen I want to be.
So we have time for a couple more questions.
I believe, Scott, she was waiting here with the mic.
No.
Okay, please.
Thank you so much. I think I congratulate you for investing your life in this research, because the misconceptions, even about inheritance, everywhere in the world you say, oh, the boy gets 2, boy gets 2. Only after the wills, and oh, the woman's witness is only half. You need 2. Only in financial matters. Please, you know, in the coming century, we have to clarify these things. And Professor Fazlur Rahman very clearly researched the punishment of stoning. And he said, how can you stone someone half to death? The punishment of a slave girl who commits the same crime is half. Show me how you stone someone half to death. There is no indication for stoning in the Quran. And I think too many I don't know, stories. History is so full of inaccuracies. As we can see, yesterday's debate today can be interpreted by 10 different people differently. And so please, we need to do a lot of research and clarify these things, because these have, and the Quran itself says that you can do it this way only if you have not written a will. And I'll just remind you, it's a duty. If you have something to leave for your children, make sure that the child who needs it more gets more, and the one who doesn't. But I mean, why should the son always be getting everything? Thank you.
Over here, please. Here, we have a question here.
My name is Dr. Khalid Abdul-Sami. I have a comment. I want your opinion on this comment. Several states in this country have banned the Sharia law. They have passed the legislation that is not compatible with the Constitution of the United States of America. According to my knowledge, what I have read, Constitution of the United States is based on Magna Carta. Magna Carta has been derived from the last sermon of the Prophet. For example, writ of habeas corpus was mentioned in the last sermon of the Prophet, that nobody can be imprisoned for more than 2 days without producing in front of the judge. and this is incorporated in Magna Carta, and that is taken from Magna Carta to American Constitution. How Sharia law can be not compatible with American Constitution, that they are passing the laws, the American Sharia law is against the Constitution of the United States of America. I want your comment.
I'm sorry, I'm not sure what your question is. Can you, is your question why? Actually, can you just ask the question again? Sorry.
Let me ask you again that writ of habeas corpus. Understand what is writ of habeas corpus?
Yes.
Okay. Writ of habeas corpus first time mentioned in the last sermon of the prophet.
Okay, so let me just. Okay, so I'm not going to get. I don't know the connection between the the Magna Carta and the connection to the prophet's last sermon, and I'm not a constitutional lawyer. But I will say that these anti-Sharia legislation is racism at worst and bigotry at best. That's what it is. And they've all been struck by the higher courts. I mean, the Constitution cannot recognize a foreign legal system or legal law. And by the way, the Sharia can't apply to non-Muslims. So it can't work anyways. And according to Islamic legal theory, there needs to be a caliph in place, and there's no caliph. I mean, I'm sure Donald Trump would want to be a caliph, but he isn't one. So there's a lot of barriers, even from within the Islamic legal tradition, that prevents it, let alone from the U.S. Constitution.
So it's 9 o'clock, and are you all okay for one or two more?
Sure.
Because I know people, we got to get you guys out to vote at 6 a.m. They open up.
That's right.
So I'm anxious, we got to close this down, because we can keep going, as the president said, we can go all night. We'll do one here and one there, and they've got to be short. Okay?
Okay, since you mentioned the caliphs, the first caliph of Islam and the second caliph, both, the first caliph made a mandatory for zakat, which is mentioned mandatory for everybody, to forcibly collect from the public. That was not in line with the wording of the Quran. Also, the second caliph suspended the hudud, the rule for cutting the hands of a thief for a certain period, and using his own rationale. So my question is, can that give some room for interpreting these verses contextually? And also the term hudud, at least the way we understand it, like the limit. So can that be considered?
Thank you. So the term hudud in Islamic jurisprudence, punishments and offenses, that term does not exist as such in the Quran. It's used 14 times, and it does not mean fixed punishments or offenses. It means, as the gentleman said, limits. So in the Quran, when it says "Tilka hududullah fala taqrabuha," these are the limits of God, so do not come near them. It's actually talking about marital discord, and that don't say divorce to your wife and then keep her, in the house, and and then be a jerk to her, basically. If you're going to divorce her, then divorce her. If you're not, then maintain the limits of God. Do not go near them. So the more interesting question is, why are fixed punishments and offenses called hudud? This term in Islamic jurisprudence. Now, the idea, what the gentleman is referring to, with regard to amputation, there's a verse in the Quran that says, amputate the hand of the male or the female thief, which is, by the way, what everybody was doing in 7th century Arabia. So, that's all it says in the verse. But laws need to be predictable. Laws need to have a certain morality to them. Laws need to have a certain objectivity to them. We can't wake up tomorrow and think yellow means stop, and green means go, and red means caution, and then the next day red means stop or something, and then yellow means go. Like, there needs to be consistency for law to have legitimacy. And so Muslim jurists over time developed reasons for why certain things must exist. And what they did is that they also developed consistency with the law. So how do we apply corporal or capital punishments in cases? So they developed different legal rulings. One of them was that the that a punishment, a person cannot be punished for a crime if he commits an offense or she commits an offense under duress. And so that makes perfect sense. You know, as I was saying at the dinner, if I go and get a gun thinking I want to kill some guy and I kill him, that's intentional homicide. But if I'm sleeping in bed and somebody comes into my house and I happen to have a gun and I'm scared for my life and I shoot him, that's self-defense. So even though there's death in both, it depends on what the circumstances. And so it's in that same way that Muslim jurists were saying, well, when are these corporal punishments applicable? When are capital punishments applicable? Well, they said that, well, you have to suspend them or you have to vacate them when there's duress. And so one of the caliphs, the leaders after the time of the Prophet, he suspended any sort of theft convictions because there was a famine and people were stealing food. And so he said, well, people are stealing food because otherwise they're going to die, so it would be unfair to call them criminals. So he suspended it. And so that's what the gentleman is referencing. So the idea of duress.
I'm sorry, we can keep going on into the night. Do you want to offer one of the last questions?
I think you have the mic, so you were in line. So
okay, very quickly. So, thank you for your book on Dr. Sabar Khurshid, for your book on Triple Talaq. It's worth reading. It's available on Amazon and Oxford, I think. The question is, when the jurists come to these conclusions, how much role does the ratio legis play in it? Is it just some judges who use it, or should it be part of how you derive at the conclusion?
Well, I think the judges need to reflect on this. There are, as you could see in these 5 judgments, there was a variety of attitudes and positions that they took. And they need to think, they need to, in an appropriate case, they need to consider how these cases should be decided. They're different from contract, they're different from crime, and they're different from anything else that they do. So I think that they have to examine at some point what are the inputs that we need, what are the constraints that we must observe, and what are the areas in which we can do something similar but not quite independent of what the scholars would do. And I think they should provide guidance to themselves, as indeed for the next generation of judges. But it'll have to be done in an appropriate case, hopefully advised by the right kind of lawyers. Because if the lawyers don't understand it, and they do it in a technical sort of way, the judges are hardly likely to be able to do it.
Before you run, Professor Hawk, would you like to thank 2 people that you asked me to thank? And I would love for you.
Today's evening has been possible because Dr. Javed Akhtar brought Mr. Salman Khurshid to Chicago and to Elmhursut College this evening, and Dr. Scott Alexander brought Dr. Atif Rizwan to Chicago. He has already joined CTU, Catholic Theological Union, as assistant professor in Interreligious Studies and Islam program. So we are thankful to these 2 people for helping us to secure these scholars for this evening. I see here Brother Dawood Kaswet, President of American Islamic College, Dr. Niazi, President of Northwestern Suburban College, Brother Kaisruddin, 2 times President of Council of Islamic Organization. My friend Mr. David Fox Gruber has been Professor of World Religion and always helps me in my teaching here. So I want to thank all these people for being here this evening. Thank you.
As you get ready to run, we also need to thank Professor Hawk for all of his joy. He's backbone of our team here. You see in the back of your program, next Wednesday at 7 o'clock, Dr. Stan Davis has an honorary degree from this college, and he has been a dear friend to the Muslim community. He's going to be talking here on campus. We need you to come out and to help get people to join us. Thank you all for coming. And